Well, welcome back to the Cordell and Cordell Town Hall. I'm Scott Trout, CEO and managing partner of Cordell Cordell. Glad you're back in 2022. And what better way to start than talking about plans for divorce, getting ready? What do you do? There's all kinds of directions you can go. We want to kind of simply outline some of the things you can do as you're considering it, facing it. Maybe you've gone through it, want to go talk a little bit about what we suggest you should do in advance of perhaps meeting with an attorney and talking about it, because that is always the best way, is scheduling a consultation with an attorney who practices exclusively in family law, like we do at Cordell Cordell. You can always schedule a consult on the phone, in person, virtually, however is appropriate for you. You can find us on the web at cordellcordell.com or give us a call at 866-DADS-LAW, 866-DADS-LAW. We have offices around the country, including the United Kingdom. So let's get started. Reminder, we're going to be taking a live questions from you and try to get you some answers and some direction. But always keep in mind that we can't give you legal advice. It's more appropriate and actually more sound to do that in a consultation. We don't have all the information from you. So this is more informational and educational. So just want to caution you, this cannot be legal advice, and we're not going to do it because our panel isn't licensed in every state. We're going to have them join here in just a second. And so the unique facts and situation that you may have can only be dealt with an attorney in that consultation. That's why we always encourage it. But this is a great first step to preparing for divorce and getting ready for divorce action. Even if it's a subsequent action, there are some spillover and commonalities between modifications and divorce as well. So if you have questions, put those in the Q&A section. Go ahead and just put your first name and perhaps the state that you live in. And if we have one of our panel that's here, we'll try to give that to them. They can give you some appropriate direction for that as well. So we want to make sure you can do that. The Q&A section is the place to do that. We'll continue to remind you throughout today's town hall. We'll devote that last 15 or so minutes to the live question and answer session and section of today's town hall. But if you don't want a question answered today, you can remember to submit those via email at townhalls@cordelllaw.com. Townhalls@cordelllaw.com. We already have some questions that we'll talk about again when we get to the live question and answer session, but you can do that now. Submit those before it gets too late as we get going. So let's introduce our experienced panel. We've had them before. We'll introduce them to you now. And we welcome to the virtual town hall. We're talking about getting ready for divorce in the new year. Christina down in Miami, welcome.
Hi, welcome, Scott.
So we're going to go ahead and let's talk about Jonathan over in Utah. Welcome.
Welcome. Thank you. Glad to be here today. Jonathan Winn here. I've been practicing divorce law for about 14 years. I've been with Cordell for about 11 years. I'm here in the Utah office, but I'm also licensed in Arizona. So hopefully I can give you guys some great tips today.
Thanks, Jonathan. Let's go to the other side over in Connecticut. Alix, welcome back.
Thanks for having me back. I am licensed in Connecticut. I've been with Cordell almost 3 years now. I've been practicing exclusively divorce law for about the last 9 years or so. So looking forward to today's town hall.
And rounding out the panel in Pennsylvania, welcome back, Cara.
Hi, Scott. Thanks for having me. As you said, I'm in Allentown, Pennsylvania. I've been with Cordell for a little bit over 2 years now, and excited to see what we talk about today.
Great. And don't forget, continue to submit your questions in the Q&A section. Make sure to name and where you are. We have offices around the country, including the United Kingdom as well. So you can check us out at cordellcordell.com or cordellcordell.co.uk for those in the United Kingdom. So let's take a real quick break. We'll be right back after this.
For many men, divorce casts a long shadow across every part of their lives. Your usual routines and familiar places are no longer inviting, and time spent with friends, even family, is no longer comforting. But you don't have to walk through this alone. We can help. For more than 30 years, Cordell Cordell has guided men through the challenges of divorce. You're not alone. Call Cordell Cordell, a partner men can count on.
All right, welcome back. Don't forget Q&A. We have some questions that have rolled in, but let's get started while we're here. We have just a short while together. We're going to start with Christina. You know, guys are always, it's a stressful period. You don't know where to turn. I was just talking to someone today about, the adage, how do you eat an elephant one bite at a time? Divorce is the elephant in the room, and you can try to eat it all at once and be stressed out and really get nowhere. Or you can try to break it down. And that's what we want to do today and try to give you 4 or 5 concise areas to focus on that are particularly unrelated to the law. We want to talk about just strategy things. And this is where we start with you, Christina. And it's always good, whether you're at a weekend, take divorce out of it. You want to get a to-do list done. You want to do things this weekend, or you want to get your kids ready for school, a to-do list. Those lists are clearly important to start somehow to get you organized, right? So start making a list.
Yeah, Scott, that's right. You want to start making a list of all the accounts you may have, whether it's marital, non-marital. You want to make a list of all bank accounts you have, credit card accounts, retirement accounts, stock accounts. A lot of times you can get a credit report, and that'll help you narrow down and maybe even remind you of some accounts you may have that you just forgot about. Another thing you can do is take a look at if you have some documents laying around in a filing cabinet, just take a look through it. And that can also often remind you about some trusts that you may have had or a safe deposit box that you just forgot about. Another thing within making a list is that a party may think, well, I don't have to provide this account. I haven't used this credit card in over a year. Well, you may be incorrect. You want to make sure you let your attorney know of all accounts that you have, whether active or inactive.
Let me ask you real quickly. I think it's such a great starting point. Many times when I mentioned the consultation early on, in order to effectively advise and counsel and develop a strategy, you have to know kind of what you're dealing with. It's like a doctor. Hi, why are you here to see me? And they want to describe the symptoms. They want to describe the problem. And so for us, it's analyzing what we have. And you mentioned early on, bank accounts, credit card statements, anything. Those are the gathering points where you want to get those together to be able to fully identify, right, to your attorney, hey, this is what I have. What is likely? What do I need to do? What's likely to happen? Where can we go with this? So it's got to be, and getting that all the way, it's got to be helpful to you, particularly Christina, as a practitioner, where a client comes in somewhat organized with what they have, right?
Yes, exactly. That's going to make it a lot easier for your attorney. Once you provide that list to your attorney, then you want to make a list of what's important to you to keep as part of the divorce. There may be some accounts that a party doesn't care about. Other accounts they truly want to keep. Maybe there's some money in that account that they had previously contributed and want that money returned to them and want to keep that money. So again, it's very important for you to make a separate list of what you want to keep untouched from the opposing party. And it's not just accounts or money. It could be a piece of furniture, a piano, something that was handed down from a family and that you want to keep untouched.
And I think the list is such a great place to start for guys, simply because it does facilitate, the consultation they have with you. And that is, I have these bank accounts, I have this retirement account, and they don't have to have the statements yet. We're going to get to that, I know, with Jonathan, but they can at least identify what they have. So there may be something that you came into the marriage with. I inherited a bank account, and that's an important piece of the conversation. And it really is about sitting down and saying, all right, what do I have? And then, as you mentioned, making a list of what's important, but that also includes, in every new year, I have friends who sit down on January 1st during the holiday, and they make a list of goals that they have. And I think that's so important, especially in divorce, is to make a list of goals, because there's no way to accomplish what you want if we don't know what you want. I mean, typically as practitioners, right, we have an idea. If you have kids, we got to talk about the custody issue. But maybe it's that, we want to prioritize what's most important to you. Believe me, there are priorities across the board. I've had guys, their number one priority among anything else is their retirement, their pension, whatever it is they worked hard for. And everything else is secondary. When you and I, Christina, may think, well, let's talk about custody right out of the gate, because that obviously has to be the most important thing. But so making a list of goals, because every client is unique and different, right?
Yes, that's right, Scott. So you definitely want to make a list for your attorney of the goals, what you want out of this divorce action. If it's time sharing, then just stress that to your attorney and make it part of your list. If it's more concerned about, well, I don't want to litigate so much, I want to try to settle as much as I can. Well, then just make a list for your goals that includes what it is that you're willing to settle on. Oftentimes you may request everything that benefits you in the beginning, and then you end up settling for less than that, but you're okay with it. So it's important for your attorney to know that, and not just because your attorney is going to start there, but it lets your attorney know, okay, how important is this issue to my client?
Mm-hmm. It's like anything with a goal. You could go to a financial planner, and that financial planner could say, what are your goals? When do you want to retire? What do you want to, how much do you want to have? It's all about, that's trying to tailor that consultation. For us, we call it a legal roadmap. And that is, all right, what do we have and how do we get there? Now we live in the age of a GPS on our phones, but back then you used to just have paper maps when I grew up, and we had to figure out how to get from point A to point Z. And it was an adventure, but, or you just drive and hope to get there. But our point is that making this list, I think, is probably the best place to start in terms of identifying what your goals are and how you get there. And it's also makes your attorney's job in that consultation streamlined. It makes the best effective use of that hour that you have with them. So you can walk away with a pretty clear strategy. And also you'll get an idea of whether what you want accomplished is even possible. So that's, I think, why I think it's so important, Christina, to start there. And thanks. And it kind of leads me into, Jonathan, the question, we talked a little bit about it. And that is, there are a lot of jurisdictions around the country that, for example, here in Missouri, they have what's called a mandatory disclosure. And you have to provide, certain documents, statements, things along the way without formality. So it's a requirement within the X number of days. I just have to send it to the opposing party, these things. So it's important to, once you've made your list, to start thinking about copying documents and statements, right, Jonathan?
Yeah. I mean, if you think about a divorce, it's a lot like almost like building a home. What Christina just talked about is you get your blueprints. That's the first step. You get your blueprints. You want to know, what is this home going to look like? Step number 2, now we got to look at what material we have. And so that's what this is now talking about, is what are the materials we're going to build this home with? What is, in the legal term, we call this evidence. And evidence is divided between witness statements and exhibits or documentation. So these states, and almost every state has a mandatory disclosure, and some of them come pretty quick. You'd be surprised how fast you're going to have to start giving stuff away. So it's not something you want to delay. You want to start right out and get in front of this right from the very beginning. The more prepared you are, the less scary the process is going to be.
Yeah. And the more effective. I mean, I've had clients walk in the door with a thumb drive of all their statements, a binder, 3-ring binder full of everything that outlines it, and even an Excel spreadsheet that's already valued all their property. And I mean, some of the questions I ask typically, I don't know about you, and I'm curious, is, a client comes in and they have a marital home. Okay, what do you think it's worth? And do you have a mortgage? And what do you think is owed on it? Do you have credit card debt? What's, the balance? Do you carry a balance? What about your retirement? How much do you have? All that matters. And the more, I think, prepared you are as you're thinking about it, there's so much work that you can do in advance. And, I know there's a question that talks about, how do I do it? And how do I not raise suspicion? And we're going to get to that, which, submit your questions in the Q&A section. We have a number of them to go through. But obviously real estate, when you're talking about gathering documents, there's some things you can do with real estate, right?
Yeah, when you're looking at a divorce, you've got 3 major categories of most divorces. And some individual clients may only be 2 categories or even 1, but it's a division of your property. It's a division of your income, which would be support and spouse support, child support, and it's a division of your children. And in each of those categories, there's documentation, there's evidence that we can gather. So I mean, starting with real estate, I mean, that's probably your number 1 property. I mean, usually in most families, that's your number 1 greatest asset. So we're going to want to know, what is your house worth? Really, and that's more than just what it's valued at, but what is the equity in the house? So mortgage statements telling us what the debt is on the house. Usually you want at least 2 to 3 months of your statements, just kind of showing what that payment is. But anything you can do to value that house. Now, obviously, an appraisal is an expensive way of going it, and sometimes you don't get that right about. And as you mentioned, that might set some red flags off if you're trying to kind of keep it on the down low. But you can use like Zillow as just kind of at least an idea in the dark. You've got realtors who can do free comparative market analysis of the property. You may have done a refinance a few years ago. That'd be great to bring that refinance documents in. The banks get a lot of the documents that are very helpful for us.
Yeah.
So
I think you're right with this, particularly. I just met with a client and the equity in the house is a big issue. But I think more importantly, what I want to know is early on, I'll have a client come in and I'll say, okay, let's get everything on the table. Now let's talk about what is it, how you, if you envisioned and you can wave your magic wand to settle this case right now, how would you envision it settled? Because we need to know, for example, let's just look up Zillow. It's worth $250,000. Okay, great. You owe nothing on it. All right. And we got $250,000 to deal with. How do we divide that? And I think it's important, again, when you're going in for a first consult, and then maybe retain, you're going to spend, $175, $195 for a consult, and you want it to get something in return. So being prepared is so important. And there's just so much, and I know it's overwhelming. We said it early on. It's, eat an elephant one bite at a time. But these are the things I think if you're watching and listening, you can do it. You make your list. Now, as you said, we break down what we want to gather into different areas. And you mentioned property, but don't forget vehicles, right? You want to think about what's your vehicle worth. I had a client whose spouse had a rare Corvette, and so it had no debt on it. And the question was, what do you think it's worth? And so we went to Kelley Blue Book, right? You can use that just as kind of just a starting point.
Yeah. You got Kelley's Blue Book, which is kbb.com. You've got the NADA guides. That's another great resource. NADAguides.com. That's usually where you can find things like ATVs, boats, trailers, things that aren't in this norm. Edmunds is another place you can go. And really as a last case scenario, you can take your vehicle right into a dealership. There's a lot of these low book sale kind of dealerships. They'll give you a bid right there and tell you what they'd give you. So if there's a dispute, you can have several different values. Besides just the value of the vehicle, you want to have the debt on the vehicle. So if you got a loan on this vehicle, you're going to want to have that. There's always those unique issues you want to make sure you're bringing documentation on. So for instance, if your home or your vehicle is co-owned by someone else, if somebody either gifted it to you or gave you some money towards it, like a down payment on a house, you're going to want to make sure you have some sort of documentation on that, whether it's a canceled check, or maybe they're on title, bring a copy of the title, or maybe a trust. But make sure you're bringing that in, because those are unique circumstances. We're going to definitely want to have additional evidence to show.
Yeah, the title is key. I was trying to look for a title. I'm thinking, gosh, I don't even know how this thing's titled. Those are the things that you're going to be asked, and maybe you brought it into the marriage. And there are some states where if you transmute the property and put her name or his name on it, it may change the nature of the property, the designation of the property, and every state's a little bit different. But those are also important to think about and just be prepared for. But then you mentioned, I think early on, the last area, child support, right? And I think trying to figure out, many guys come to me and say, all right, what am I going to owe in child support if I don't get primary custody? And there's only a few ways to find that out. And be prepared. You want to have really good advice. So what should guys be thinking about gathering before to try to go and tackle that subject?
Yeah, when you're looking at either child support or spousal support, it's really factored in most states of two different aspects. It's their income and their budgets. Mm-hmm. And so documentation on your income is essential. Now, W-2 employees, that's actually pretty easy. You just give us 12 months of your bank statements and also of your W-2s and your pay stubs. That's going to clearly reflect what income's coming in. It'll be really easy to track. Usually we want at least a couple of years of taxes to kind of see if there's been a pattern. People who own their own business, it's a little more complicated because what the IRS considers your income and what the courts consider your income sometimes isn't exactly the same. Sometimes IRS will let you deduct things that the judges are going to say, nope, we're not going to consider that. And so we're going to want a lot more information if you own your own business. Usually we're going to want lots more years of your taxes to kind of show the flows and the ups and downs. We're going to want to see some financial statements from the business, and we probably want to see more of your bank statements from your business.
Yeah. And not to mention spousal support, alimony, maintenance, whatever your state may call. We want to look at one of the factors, at least in Missouri, is the standard of living. What has been your expenses? Go through your budget. What is kind of a day in the life before you separated or before, the divorce is about ready to be filed, because we want to set kind of a guideline. Maybe what you live in a state in which there's a formula. There is no formula here in Missouri. So we have to kind of create what that lifestyle expectation is and then balance it with whether or not someone can pay it. And they have to also meet their standard of living. So creating a budget or having some general ideas of what you've spent during the marriage in an average month or a year is important.
For sure. And it's actually a lot easier nowadays than it was 16 years ago, because a lot of people now are doing more and more with credit cards and debit cards. And so it's a lot easier to track your expenses than it was in a cash society we were at, a generation in the past. If you've got an actual budget, that's great. If you've been tracking it and you've got some sort of app on your phone that categorizes where your money's going, that is just fabulous. That's just gold. It's like a golden egg to your attorney. Not most people don't have that. And so really we're kind of doing some retroactive forensic accounting, and we're looking at your credit card statements, we're looking at your bank statements, and then we're categorizing what you've been spending and doing that forensic accounting to figure out, retroactively, what has this budget been the last year?
Yeah. One thing I think that's important that comes to mind a lot is healthcare benefits. What happens when you divorce? Does your spouse get healthcare? What's COBRA cost? I think that's a huge question, and a factor for a lot of my clients is how much is it going to cost her to get comparable, similar, and health insurance once we divorce? And so COBRA, for that period, whether it's 24 months, I can't remember, 36, you want to know what that's going to be from your employer, or how much, it's going to cost for them to get it. And I think that's important to try to find too.
Yeah, you want to research not only your past budget, but what is it going to look like in the future? Probably one of the greatest mistakes I see guys make is, in a separation period, they leave their $1 million house and they go into a $200 a month apartment in the West Side, and they give their wife all their money and they live off of beans and rice. And then the judge is going to look at the budget to try to make some sort of temporary alimony. And they're going to say, well, gosh, husband only needs $200 a month to live. Wife needs $20,000 a month to live. We're going to have her get all this money. So when you're thinking about your budget, also think about what's it going to look like, not just these next 3-4 months, but what's the next 30-40 years going to look like for you? Because you don't want to give the judge a false impression that this is what you're going to live like. You want to kind of think further ahead.
Yeah. I mean, you may be trying to be wise with your money, and all of this matters in terms of, every decision you make has a consequence. And that's why I always talk about getting with a lawyer soon. Make sure you understand kind of what decisions you make, what effects they have, which leads us to Cara. Thanks, Jonathan. One of the things I like to tell clients is they often ask me about mediation. And I'll say, look, I love doing informal mediation. And by that, I mean, I like getting my client in. We've made a list, we've gathered some of the statements, and now we want to talk about strategy. We want to talk about my options, and we want to talk about what is likely. I'll call it the best case and worst case scenario, best case, worst, and then likely. And then we can try to engage the other side quickly without spending a lot of money to see and explore opportunities for settlement. So I got to imagine, Cara, that trying to take that consult, let's just use this as we go through, to learn a little bit more about your options and the strategy you should take so you understand whether it makes sense to pursue something is important.
Yeah, I find that clients, they come to us and they immediately want to establish the date of separation, right? So they immediately want to file the divorce complaint, get things moving. But more often than not anymore, I think I find kind of pumping the brakes with clients and saying, listen, let's assess your exposure here, because realistically, whether you're entitled to something in the divorce or you're obligated to pay something, you want to know that before you file, and those are a lot of things that we've talked about in follow-up meetings early on before filing a divorce complaint, even just so that clients have an expectation as to what they're really looking at. It typically doesn't prevent them from filing anything, but it at least gives them that expectation. And there's other ways to assess date of separation. In Pennsylvania, we don't have a legal date of separation, but there are ways to assess that so that you don't just establish it through filing the divorce complaint. We can still establish that even if we're still looking at exposure and what's owed or what's going to be the entitlement as well.
Yeah, I mean, I think it's important. I've said it a lot. I talk about strategizing and preparing and understanding kind of what's going to happen and not pulling the trigger. Many guys are saying, hey, I want to file, I want to get going, let's do it, before they even think about what's possible. I mean, look, take something in the news today. We've got Russia on the border of Ukraine. Can you imagine them saying, okay, you know what we're going to do? We're going to invade first, and then we'll figure out a strategy after I get across the border, or we're going to figure out what happens. I get it. We want to be in a rush at certain times to file, or Russia wants to be in a rush to try to invade. But you know, they're certainly, if anything, you want to look at that as an example of strategy. They're clearly taking their time trying to figure out, dipping their toe in the water, right? They're strategizing. They're trying to figure out how far they can go. That's the point I think when you said is, let's take a look at all the documents that Jonathan mentioned in the list that we talked about with Christina, and let's see what's available. Let's run. I mean, I have guys that saying, okay, how much am I going to pay in child support? Can you just do that for me? Can you just run me a chart, the calculation? So I imagine you get that as well when you're talking to clients originally, right?
Absolutely. More times than not, I run support numbers. That's one of the first things that I do with clients, just because, it's important, especially where we are in Pennsylvania. There's different factors that can diminish any kind of obligation and support. So we want to know up front, what is your custody schedule like, if there is one? And what are the factors? I think someone had mentioned it earlier about kind of the lifestyle. What are the expenses? All those sorts of things. Those are all factors that can diminish a client's obligation for support. And we want to take those into consideration, because realistically, sometimes they come to us and they're already paying a support number, or they don't know what to expect in support, and then they're not saving correctly, or they're overspending in their own lives. So that really ends up throwing them for a loop too. So yes, one of the first things that we do are run support numbers, do all of that, and then also talk about the different scenarios that could happen as well. It's always good, like you said, go in with a strategy rather than, go in without one. And so we want to talk about the different scenarios that can happen, because oftentimes too, what can happen is, instead of having to go through, protracted hearing, we can come up with an agreement with the other side that's favorable to oftentimes both sides. And that's helpful as well. So always having that strategy, running those support numbers, getting the correct documentation. I think that's key. It's very important to, start off your case like that.
And you think you can't underemphasize enough multiple scenarios. I recently ran a child support chart for a client, but I had 5 different charts because there were multiple scenarios, and some of them involved overtime for him. Wife was underemployed. So we ran multiple numbers based upon what I thought we could impute, minimum wage, something a little bit higher, just so that he had an idea in this before we filed what we were getting into. And that also goes for clients that may be watching, or people that may be watching right now, about modifications. I'm getting ready to talk to a client and we're debating whether or not we should be filing motion to modify and terminate spousal support. So we're going through all these different scenarios before we pull the trigger. And I mentioned that because, Cara, as we kind of wrap up your section, it's oftentimes important to think about all the scenarios, the facts, before pulling the trigger and filing. And one that comes to mind is I've had clients say, she uses weed all the time. I want that in the pleading. I want to use that as custody against her for custody. She smokes, she gets high in front of the kids. And if I didn't ask the follow-up question and just put that blindly in the pleading and say, okay, do you smoke weed as well? It's my favorite is, I want her drug tested. And I always say, okay, we're going to do it, but you need to be prepared to be drug tested as well. And if it's clean, we're good to go. If not, you need to start telling me right now, if there's a chance you come back positive, it's not going to work well for you. So you want to weigh out all potential scenarios before you actually get your attorney to file the pleadings, right? And make sure it's, accurate and fully complete, right?
Absolutely. I mean, multiple times, I think we've all kind of fallen into that pitfall where, our client wants a drug test. And I always say to them, if you want one, you have to be willing to take one. So you have to be honest and upfront, because what's going to be even worse is if we get in front of a conference officer or a judge and we say, oh yeah, our client will take it. And then they, come up positive with something, it doesn't work out well for anybody realistically. And that plays into, I know in Pennsylvania, we have fault-based grounds versus no fault-based grounds for filing a divorce, and talking about strategy and things like that. fault-based grounds, it's really established by case law and what you can file that for. And oftentimes it's a dispute, obviously, because it can be, a whole range of things: adultery, mental abuse, physical abuse, those sorts of things. I had a client that I advised, hire a private investigator first. Don't file anything yet. Hire the private investigator, get the photos that you're looking for, get, the evidence and everything like that, so that when we do file, if we file for fault-based grounds, we have that evidence to back it up. So that's another part of the strategy too, is what ultimately are you going to want to file? And do you have the information to back that up separately and above from what your client's actually saying?
Yeah. So don't forget to submit your questions that you have. I know you have them. We have a bunch that are already submitted in the Q&A section. So you can do that now. Again, first name, state where you are. We'll try to distribute that to everyone as we continue going along. We're only about 10, 15 minutes from that. And so Alix, let's go talk about maybe the more technical part of, as we've gone through, we make a list, we get our documents, we talk about making sure everything's accurate, we talk about strategy. Now we want to kind of educate, something we can't do here necessarily, but we want to educate and learn about the law, right? And that's equally important, that you understand what the law says, and then we want to merge that and somehow marry that to the goals, right?
Yeah, absolutely. I think this is where it's really important that you come in and meet with an attorney to understand how the laws of the state that you reside in are going to impact your specific case. As you said earlier, every case is unique. There's a certain set of circumstances that are going to be unique to your case, despite that there are themes that run through. So the law and how it applies to your unique situation is going to be really important. For example, if you are moving money around in certain states, you might have an issue with that if it's directly before the filing. Like Connecticut, there's automatic orders. You can't move money around once it's filed. But then somebody could actually look back and say, well, you did it 2 days before you filed, so was there an anticipation? So there's really important things that you should look at, and that's just one of them, but into how the law is going to apply to the facts that are specific to your case.
Yeah. So you can break that type of, and I think the best way to do it with your attorney is, okay, if I have kids, let's talk about custody. And that is, you can go all across the state, and the terminology used is different at times. Some use primary, some use residential, some use shared. You got to understand what that means first and foremost. But I think also when it comes to even legal, you have some states around the country who have different standards in terms of where should the court start. You have to understand and get a grasp on understanding what the law is going to provide as it relates to custody, if you've got that, because that varies based upon your goals and what the court will consider, right?
That's correct. I mean, for example, in Connecticut, there's a presumption of joint legal custody. So, obviously that may or may not be the case in every other state, but it's important to know that, because then it may inform the decision as to, what you're looking at for your parenting plan, for what you're looking at. Was it shared custody? Is it someone going to have primary or just have visitation? And what does that look like? And what is the court going to be looking at? What sort of factors is the court going to take into consideration when they're looking at your situation?
Yes, I mean, same goes for child support. You want to know how it's calculated. Every state tends to have some similarities in terms of establishing the amount, but maybe there's a conflict of laws question. Maybe that, one party lives in Missouri and one lives in Connecticut, and you have to kind of evaluate which laws are going to be applied. Depends upon where you file. I mean, I think that, you want to break it down to that, and you can even go into property and how you're going to divide it. What's considered marital? I think in Arizona and California, particularly, date of separation is important because that establishes value. So I think all that matters in terms of those two areas as well, right?
Yeah, absolutely. I mean, I think when you're looking at, for example, property settlement, things like that, some states are a straight 50-50. I mean, it is, it's just, you're going to split the assets down the middle. Connecticut is not that. Connecticut is an equitable distribution state. So that means the court has discretion with a lot of different factors that they're going to look at to say, hey, this is maybe how this is going to shake out when we're dividing up the marital estate. So you have to understand how those factors in your state are going to impact your case. And, how long was the marriage? Do you both work? Is there someone who is a stay-at-home parent? The reasons for the breakdown of the marriage can also come into play with things like that. But understanding how that interplay occurs and what those different factors are going to be, reviewed and how that impacts based on your individual circumstances is really important.
Yeah. And I think some of a pitfall, it's a huge one, is everyone may have a friend who practices law, or they have a friend who's gone through divorce. And so he said that when his friend went through it, this is the way the court handled it. But my lawyer, who I use for real estate, he told me that, child support's this way. So you have to use that with caution, right? Because obviously there's a reason we just do family law, right?
Yeah. It's something I hear all the time. Well, my friend had this, and, his kid did this, and, the mom did this. And it's something that I have to caution clients on all the time. Every situation, even though there are similar themes throughout all of them, property division, custody, child support, alimony, those types of things, every case is different. There is something unique in every single case. It's what makes this area of law so interesting. And you have to be able to understand that what is right for your case and the factors that are being reviewed and looked at by the court, while they're all the same factors, they may apply differently in every single case. There may be something that changes the direction of your case that is, maybe similar to your friends, but there's a substantial difference in one key piece that, could change the whole course of it.
Yeah, I mean, I get asked a lot, hey, I've got this question I hate to ask you, but, it involves contracts or real estate. And it's like anything. My daughter's a nurse, and she can triage every patient that walks in the door, but she's in labor and delivery. And certainly if she wants to be asked a technical question about oncology, she's not going to know. I mean, she can triage the patient and we can stabilize the client. If you were to come in the door, probably point you in the right direction. But that's, I think, the caution is take everything that you get with a grain of salt. And that is, hey, it's okay. It's probably sound advice, but it's not the best advice. So it's, trust, but verify. And that's why I've always said, when you want a consultation, and I've said it in seminars in person, and that is find an attorney that practices exclusively in family law. And there's a reason. It's, I mentioned oncology or cardiology or whatever it may be, dermatology or allergy. You go to specialists for a reason in medicine, and that is because that's what they do. And they know some of the nuances. And for us, it just happens to be kind of this double side. And that is, we've got guys and we've got family law. And I think that's important to do that. And so I imagine, though, and kind of rounding out, Alix, I mean, once you get the law, and I always, like I said, referred to it earlier, and that is the legal roadmap. Once you understand what the law allows, I mean, it's got to be able to help you dictate what you can do.
Yeah, absolutely. I think, for example, decisions as to whether or not you want to move out of the house prior to setting up a parenting plan. I mean, that is something that, you look at the laws of your state and you determine, is that the right thing to do? I mean, that could be a decision that could impact something negatively down the road. And so you want to make sure that you understand that and you're making the right decisions in anticipation of filing. And again, getting all that information together for your attorneys that we've spoken about earlier, I mean, that's going to help your attorney even, advise you even better, because then they're going to have a full picture of what's really going on and understand, the best way to help you through, the first steps there.
All right, Cara, Christina, I want to kind of round out the topic before we go to the lightning round of question answers. Now's your chance. If you want a question, submit it to the Q&A section. We'll get to it in just a second here. Prioritize. We kind of conclude the preparation. We talked about kind of making a list and goals and documents and strategy and the law itself. But now we can talk about finances, kind of getting your house in order. And that's got to be equally important, whether it be, what do you do with your bank accounts? You just want to kind of prep your finances before you file, right?
Yes, that's right, Scott. If you have a joint bank account and you currently have your paycheck going in there and you're afraid that the opposing party is just going to wipe out that bank account, then you may want to think about that as you're getting close to filing. Do I want to maybe change my paycheck to go into my separate account? With that, you also want to make sure that you can explain transactions on your bank account and credit card statements. If you know that the opposing party is going to make some sort of allegations about alcohol use, well, then you want to go through those credit card statements and see, are there liquor store purchases? Because that's as soon as they see that, they're definitely going to use that against you. So those are the type of things that you should do prior to filing. Take a look at that and just make sure you can explain your transactions. Another thing with self-employed business owners, I often see that they put their personal expenses and business expenses all together and they run everything out of one account. This could be bad for you in litigation. You want to make sure you're separating business and personal and have that run out of two separate accounts. If it's a business purchase, then it's under the business account. If it's a personal expense, then make sure it's out of your personal account. So these are the type of things you want to take care of before you go ahead and you file.
Yeah. And Cara, we talk about a little bit about maybe property I've mentioned early on. There may be something you inherited or something that you brought in with you. You have options in terms of, how do you consider it? And you think about what we've talked about earlier, and that is getting ready, making a list, identifying property. I mean, I guess your options would be, you want to make sure if there's something that you brought into the marriage, whatever it may be, it could be a box of record labels, or it could be inherited money, a bank account. You want to make sure it's noted and accounted and how it was acquired so that you can take it, right?
Absolutely, Scott. The biggest thing that I tell clients, especially when, what I was talking about earlier with the exposure, you want to go through the house and really start preparing yourself. What is it that you want to take? What is it that you want to leave? And maybe identifying some of the things that maybe you would want to take, but you'd be okay with leaving, because sometimes we can offer that up as sort of like a middle ground. Hey, I'm, giving you this. I wanted it, but I'm going to give it to you because I know that you want it more. Identifying all that, taking pictures of everything as well is very important, because, oftentimes we do see where, clients come to us and there's already an exclusive possession petition filed. There's already some sort of protection from abuse order filed, which evicts them from the home, that sort of thing, where then we're working backwards. We have to figure out what are the items that we wanted to take, what are the items that we wanted to value, all that sort of thing. So taking pictures, making lists, making sure exactly where it is in the house is written down as well is important too, because oftentimes when, clients go back into the house, things are missing, we can say, it was in this box under this book and it's not there anymore. And opposing party is going to have a really hard time explaining to a judge where they put that.
Yeah. I mean, I've said in seminars, 10 stupidest mistakes, and that is failing to really consider whether or not, if you're going to leave the house, as you mentioned, leaving it or taking it. Because I've said, look, if you've got something that's sentimental to you and your relationship is terrible and you've got to get out of there, that box of things is going to either disappear and they claim you took it, or it'll be sold on eBay or left out in the snow, in the rain, set on fire. I've seen it all. I'm telling you, I've seen it. And then or if it just disappears, they get on the stand and they say, well, I saw him take it out of the house, when you never did. And so I've said, if you want it, you need to take it. It's kind of those things, it's take it or leave it or split it, whatever it may be. But those are the decisions where I've said that actions have consequences, decisions have consequences. And if you haven't had that conversation with your attorney before leaving about whether you should take it, leave it, or split it, there's going to be something that happens with it that you may not be happy with. So I think that's really, really important. Okay, so we have some questions. Let's get to the live question round, and let me pull those up and we'll kind of get right at it. Let me scroll up here real quickly, and you still have time to submit your questions if you want. You can do that. So let me just go right to Jonathan here. Jonathan Marty has a question. I've met a guy that had a child with a lady. They are not married. The child is now 11 and he'd like to have a relationship with his son. He has contributed money occasionally, but there are no court orders. What is the best avenue pursuing or establishing a relationship? Paternity. What's the best way to do that?
Okay. Well, obviously you're going to want to talk to an attorney in your state. Looks like that's Nebraska. This would be some sort of a paternity action. Usually what you should be prepared for is, as soon as you start pushing forward on the paternity action, the mother may be pushing back with basically a termination action. That's what we typically see, some sort of abandonment claim if there's been 11 years. And so you're going to be playing almost as much defense as you are offense in a situation of that nature. You're going to want to be able to show that it's really in the best interest of that child, that relationship to be bonded. So means to mean you're going to have to show you're a good dad. You're going to have a good influence in the child's life. Number one thing you want to be prepared for is your life's going to be put under scrutiny. How you doing? Do you have a good job? Do you have a good relationships with other people? Are you clean? You got a good clean criminal history? Maybe you need to go and expunge some records. To make sure you're presenting yourself as a good option for this child to now have a relationship with. But you're also going to have a lot of financial backing. If you're going to want to come in and say, look, I want to be dad now, they may come back and say, all right, well, here's 11 years of child support, so be prepared to have the financial backing to come in and say, look, I'm ready to make amends and to repair that bridge.
All right, Alix, the question from Larry says, the mother of our child keeps asking for extra money to help feed our son. She gets support every week. Order has support split between us, and she doesn't want to work, seeing she is raising a baby. And then the follow-up question from Larry was, can I use the money she's asking for be used towards any arrears? So it really is, from what I understand, Alix, and maybe infer some facts here, that maybe there's a court order for child support. Larry's wife or the mother of the child keeps saying, hey, I need more for food. Does he have to do it? Should he do it? And if he's in arrears, can he just pay extra money towards that?
I think that's there's a lot more information that is definitely needed for that question. And obviously it depends on the state that you're in and how the child support guidelines are looked at in your state. I would caution about just giving extra money if you have a court order that gives you a support amount. Presumably that support amount was calculated to determine, based on your incomes, what the appropriate support was for, the child that is the subject of the support. So I don't know that it would just automatically, again, and this depends on the state that you're in and what the guidelines in your state say, but it just wouldn't necessarily go to arrears unless it's designated as such. Like, for example, in Connecticut, usually if there's an arrearage, there's an additional amount tacked on to the weekly support amount that we work with. And so that's how you would pay the support. And if it goes through, for example, the state for payments, there's maybe a way to track that. If you're giving it directly to her, there isn't a way to track that necessarily, unless you're doing it, by a bank transfer or check or something. So I would be very cautious about that. I think if there's a change in income or circumstances, maybe there's a modification that is needed, but I would be very concerned about just giving that when you already have a court order that presumably had the right support amount at the time.
Yep. I'll handle this one real quickly. There was a question whether we represent people other than men, which we do around the country. I'd say probably 90, it depends on the office. You may see about probably 95% of our clients are men, but we represent, we're not exclusive men, but we are predominantly men, but I have clients that are other than men, and so we do. So you can check with your local office and give us a call, 866-DADS-LAW. Let's go to Cara. I know, Cara, this is somewhat in line. You had mentioned there's it's a fault state, I think, in Pennsylvania, but Scott in North Carolina, obviously you're not licensed there, but has a question about the 1-year separation period before you can file for divorce. I don't know if there's and anyone on the panel can probably try to answer this as well if they have one. They want to know, is there a legal process to officially separate, or do you have to move out or start the clock in terms of separating? And is that 1-year requirement, out of the house in order to file? So we'll start with Cara. If anyone else has anything to kind of supplement, we'll go from there.
Right. So as you said, I'm not licensed in North Carolina, but I think it kind of goes in with similar factors that Pennsylvania sometimes uses. And that's, is there anyone from either family or friends that can come in and testify and say, this is the date in which I knew they weren't holding themselves out as a married couple anymore? Did they start separating bank accounts? Did one party go and get some sort of apartment or new home? Those are all factors, I think, in establishing separation without having to file anything. Now, in Pennsylvania, we do, if one party is not cooperating, 1 year from date of separation, we can file a motion to appoint a master, which then kind of forces everyone to fall in line, or realistically, waive your rights to things. So I don't know if that's similar to what they were asking, but that's typically where we would look into the factors. What can we use to establish that date of separation a year ago to kind of move the case along?
Yeah, and I'll open it up. Jonathan, do you have anything?
I was just going to mention, a separation can make so much, there's so much evidence that can be entailed in that separation, especially an entire year. So before you do anything with a separation, talk to your attorney, because there could be some very long-standing effects on how you separate, who stays in the house, who leaves the house, what you're doing with your kids during that 1 year. So, when you're thinking about when should I talk to an attorney, when should I get this process started, for sure, months before a separation occurs.
And I think, for example, there are like Illinois, there was a time where you could waive the period of separation by agreement. It's certainly someone you want to have a conversation. We have offices in Charlotte and Wilmington, and you want to go ahead and Raleigh, maybe have that conversation. You can have it virtually. You can have it on the phone, in person. Give us a call and we'll kind of straighten it out in terms of that period of separation. Let's go to Christina. The question is what do I do if I have a separation agreement that's already been presented, I imagine presented or filed to the court? Can it be binding on the divorce proceeding? And I will also, when you're finished, Christina, mention how Missouri law treats that. But what happens in Florida with a separation agreement that's been signed and filed?
Sure. If the agreement has been signed, yes, it could be binding on your divorce, depending on the state that you're in. I can tell you that here in Florida, separation agreements aren't specifically binding. However, if you have a prenuptial agreement, that may be binding on your divorce, but separation agreements aren't really binding here in Florida.
And I'll mention Missouri, for example. All separation agreements may, look to be a contract, but under family law and under the statutes and the case law here, they are not approved. They are not binding until a judge has reviewed it and signed off on it to what we call deemed to be unconscionable, fair, and reasonable. So I've had many occasions where, and I've always said to my clients, look, if we're going to execute this agreement, let's do it. And let's get before the judge. Let's get it run through as quickly as we can before they change their mind, because inevitably I've had them where it was a very good deal for our client. The opposing party began to second guess it and they backed out of it, and there's no recourse. And we maybe get hit with attorney's fees, but it's not binding. So I think what's important is to go ahead and have that conversation depending upon your state, find out what the rules are particularly and whether or not it's binding, because I'm sure there are some that once the ink is on the paper and it's notarized, it could be binding. So it's certainly one to explore with an attorney in your state. All right, let's go to Jonathan. If I'm going through an uncontested divorce and I'm giving my wife the house and paying off any shared bills, is there anything else she's entitled to, perhaps retirement or pension?
All right, great question. So the easiest thing for a judge is to just divide everything right down the middle. Divide the house down the middle, the retirement down the middle, the bank accounts, the vehicles. But in a lot of scenarios, we say, well, if you keep the house, I'll keep this. And if you keep this, I'll keep that. And we kind of do some offsets. Probably the most important thing to consider in your scenario is the tax consequences. So a house, if you sell your house and it's under a certain level, you're not getting taxed on it, that's cash in your hand. But if you pull money out of your retirement, you're probably going to be paying taxes on that retirement money. And that can be a 20, 30% decrease in the funds. So you definitely want to look at your net tax value when you're equalizing your estate. And you can list everything on a spreadsheet, do the math, and then kind of see where everybody ends up to kind of get that equalization. As mentioned earlier, some states are very just strictly 50-50. Other states say, well, we're going to look at the big picture of an equitable distribution. And equitable doesn't always mean equal. And so that's a factor depending on your state also.
Great. All right, there's a question that asks, if we were advising the opposing party, how would your approach differ, if at all? And I'll just handle that one. Well, it certainly would, depending upon it. Let's just say we represent the wife in a case, which I have done on a number of occasions. Certainly your strategy could be different, depends upon the facts and the circumstances. If they want or a candidate for alimony or spousal support, your recommendations are going to be slightly different. Having represented the other side, you know what to anticipate from the other side. You know what they may employ, the strategies. Retain an expert, perhaps, to talk about, revenue or income in terms of imputing income, what they should be doing with assets, what they should be doing with their expenses. I think it's certainly that's why it's unique in representing. It's not this one size fits all. I've heard that where lawyers say, well, it doesn't matter whether you represent either side. Well, I think it does. I think having done it for me, I've been doing this almost, well, gosh, 27 years, 28 years, 29 years, that it does matter. I think having done one side, you understand there are certain things you can do. And it helps you represent the other side because you know what to anticipate. So certainly the approach is different. The strategy is certainly different. And your arguments and can be different. Now, in accordance with the law, but there's certain ways you can use existing law and statutes to try to get an advantage to your clients. So certainly the approach is different. All right, Alex. Chris says, I don't want to tell my wife that I want to get a divorce because I'm concerned she'll react poorly and lash out. What can I do to start preparing my assets and accounts? Which is a great question because we talked a little bit about that today, and you can just kind of rehash that.
Yeah, I mean, I think it's a really good question, and it is a real concern for people I know. I think that, again, one of the things to start with is prepare your list, as we started with earlier. Make a list of what's important, what your goals are, what your concerns are. I mean, that's another thing to take a look at. If you think she's going to lash out, what are the concerns that you have there? Are there concerns for the welfare of the kids, if there are any, things like that? And then start making a list of those accounts and assets. If there's a concern, as stated earlier, that maybe one or the other party is going to take money out of the accounts, redirect your pay so that you're covering still everything that you need to cover, but that won't have clear access to be wiped out if that's a concern. So I think those are some of the first things that you can do to start protecting and preparing for that.
Moyo asked a question, and I'll answer it just because it's kind of fresh in my mind. Is there a written checklist of what to bring to be prepared for your first meeting? And obviously, we talked a lot about that today, but fortuitous timing, I just wrote an article that was published in the Missouri Lawyers Weekly. So if you want to look it up, Missouri Lawyers Weekly, I wrote an article about divorce month because this is the divorce month and the questions that clients have about getting prepared. And I outlined about 9 or 10 different things that you want to consider bringing with you. We've talked a lot about them today, and I'll just real quickly go through it. I'm just looking at the article now. Tax documents, individual business returns, W-2s, W-2 forms, bank statements, retirement accounts, loan documents, prenuptial agreement, huge. If you've got one, you need to bring it. Any police reports, that involve you or the relationship, wills, estate plan documents, because that's important as well. Anything about past behavior, whether it be texts, emails, anything like that, that's important. And that's just, to touch the topic of it. But there's stuff like that on the Missouri Lawyers Weekly. I wrote the article about divorce month. Have you check it out. It's a really good article just about getting prepared, and also talks about not just what to bring, but the questions to ask and the things to consider when you're looking for an attorney who practices exclusively in family law. All right, let's see. Let me get one more question in here. I'll go real quickly. Jonathan, I'm just going to toss it real quick. The question really becomes going through a divorce for a year and currently ordered temporary child support. 6 months after the order, person moved 10 miles away from the kids. It costs about $8,000 to $10,000 for the move, from the flights and shipping, purchasing a new home. Can get child support arrears adjusted due to the cost of reconnecting and getting closer to the kids? And I guess there's a lot more facts there, Jonathan, that it kind of make me wonder in terms of, why was there separation? Why was there a distance already? Those types of things. But obviously arrears, it's a different situation and they can be disconnected from cost to move. But go ahead.
Yeah, I mean, first of all, Marshall, way to go. That shows right off the bat the importance that your children have to your life. The fact you're willing to uproot and do that, huge for your children, and that's definitely showing you're putting your kids before your own career and your own personal interests. And so you're going to get a lot of good feedback from the court on that move, especially when it comes to custody. Because in your original situation, there's just no way for any sort of joint physical custody. But by you doing that, you've been able to put yourself in a situation where you can really be a part of your children's life. So it's one of those almost like the American Express old commercials of, what's the price of this and this? That move is a priceless. Yeah. Every dollar you spent, you'll get back tenfold in the relationship you have with your kids. Now, how does that handled economically? It may be more of something the court can look at in equitable distribution, but more likely than not, your benefits are really going to be your parenting and the relationships you have. And this isn't just now, we're talking the next 50 years of your life with your children.
Yeah. And there's so much that goes into, you're right, Jonathan. it's one of those things where we have to have a long conversation about the circumstances around the move, what caused it. And it's a high five on the move and making sure you made the right decision to, the court should look at that and with respect as well, no doubt. And the sacrifices you made financially and physically and all those. So have you sit down, talk a little bit further about those and really develop a strategy. Some of the things we talked about, let's look at what the law says. Let's develop a strategy in accordance with the law, and then how are we going to get there? All right, I know we had a number of other questions we just couldn't get to, but that is the end of our time. We've run over just a little bit, so I appreciate everyone joining. Check us out at CordellCordell.com. Also, we have a podcast that we drop. Go to Apple iTunes. You can check us out, the Men's Divorce, Dad's Divorce, Cordell Cordell podcast, where we talk about topics for about 15 to 20 minutes. In fact, guys, it's certainly worth just subscribing. You get alerted every time we drop a podcast, and you can check all of our content on our YouTube channel. You can check out the Cordell and Cordell YouTube channel. All of our previous podcasts, the virtual town halls, all of those are still there. You'll find the topic that really addresses some of your concerns, but encourage you to February. Let's see you at the next virtual town hall, and we look forward to you then, and we'll answer more of your questions. So thanks for joining, and until then, have a great rest of the week.